everybody. This is Katie Frekhtman, a New York City personal injury trial attorney. And today I'm coming to you and we're talking about a new appellate court division decision that just came out. And this is actually from the 4th Department of the Appeals Court. And what it did is it talked about a personal injury case involving a burn. And it was also published in a blog known as the New York Injury Cases blog. But I thought it was interesting. Basically, it involved an injury that happened in someone's apartment. A lady named Miss Frekhtman, who was 78 years old, was taking a bath, and it was May 8th of 2018, and it happened upstate in Syracuse. And what happened was she was just scalded by extremely hot water flowing from her bathtub faucet, and she had severe burns. And the lawsuit was against the apartment complex, and the plaintiff argued that her injuries were serious and the hot water tank was set too high. And so it was a non-jury trial. For whatever reason, the plaintiff's lawyer and the defense lawyer did not choose to go before a jury, and they had a judge. And the judge found that the apartment complex was at fault. And then they also allowed for $632,000. And it was divvied up like this. $450,000 was for the past, which included 2 years and 7 months of pain and suffering. And then $182,000 was for the future based on life expectancy tables. She had 9.1 years of future life expectancy, and that was a total of $632,000, which is a large amount. Now, the defendant appealed. They didn't like that. They appealed, and they argued that both liability and damages. They argued that the case should be dismissed because the plaintiff cannot prove prior notice of any issue with the hot water temperature. And then they argued, number two, on damages, that the pain and suffering was excessive. And it says here that the injury was pretty severe. It was second-degree burns to the buttocks, vagina, anus, like all over her body. She was admitted to the hospital burn unit for 3 weeks and then had to go to a rehabilitation center for a month. She had continuing pain and discomfort in the burned areas, especially when sitting or trying to sleep. She had permanent dry skin, itching sensation requiring frequent lifetime moisturizing. And, a third-degree burn, second-degree burn is a pretty serious burn. It's, pretty deep into the skin. There's like layers of skin, and getting to the second degree is pretty serious. And then the defense argued that the future pain and suffering award was excessive, but also speculative because plaintiff's own treating doctor testified that her burn wounds had fully healed as of July 2018, and she had not treated for her injuries since then. So let me see here. So go to the decision itself, and if we read the decision itself on liability, right, which is the issue of fault, what it does is it talks about the fact that after the trial was over, the judge, the Supreme Court judge, found that 90% of the fault was the defendant's and 10% of the fault was Ms. Frekhtman, the plaintiff. And then, now with respect to the appellate court, what they did was they reviewed the trial court's decision, and they said that a non-jury trial decision should not be disturbed on appeal unless it is obvious that the court's conclusions could not be reached under any fair interpretation of the evidence, especially when the findings of fact rest in large measure on considerations relating to the credibility of witnesses, right? So credibility, whether you believe a witness, whether someone is credible or not, and that was up to the judge because he was the one or she was the one listening to this case. And so they don't want to disturb that unless it's just cannot be reached on any fair interpretation of the evidence, unless the judge was just way out there. So they said that the court properly decided that defendant was negligent and defendant's negligence was a proximate cause, which is a legal cause, of the plaintiff's injuries. And remember that the defendant is arguing that they have no notice, right? Notice is just, there's actual notice where I complain to you. I say, hey, you have the water is always hot, or constructive notice, the water's been hot and you should realize it and fix it, or if you caused and created the condition. Those are the three ways you can prove notice. Now here, there's no notice. She gets into a bathtub, she turns on the faucet, it's just hot water all of a sudden. So how do they prove liability? Well, they proved it under a doctrine known as res ipsa loquitur. It's Latin, and what it means is the thing speaks for itself. Like it can't happen without negligence. So the decision here says the doctrine of res ipsa loquitur permits a jury to infer negligence from the circumstances of the occurrence. So the very fact that it happened means somebody was negligent, right? Because they're saying the trial evidence established that this lady got into a bathtub, and ordinarily something like this does not occur in the absence of someone's negligence, right? So that's the first prong of res ipsa loquitur. Now, the second prong is that it was caused by an agency or instrumentality within the exclusive control of the defendant, meaning this apartment complex controlled their hot water heater or boiler that they had in the building, and no one else could really go in there and change it, right? It's their exclusive control. It wasn't like the plaintiff had any control. She just goes into her bathtub, turns on the knob, and that's it, right? She can't control what's happening with the boiler or the temperature. So then they said that the heater generating the excessively hot water was the instrumentality under the exclusive control of the defendant, and that Ms. Frekhtman played no part in setting the water temperature. And they cite the cases. And then defense witnesses testified that only maintenance employees had access to the water heater, which was kept in a locked room in the basement of defendant's building. So it was not unreasonable to conclude that because the water heater was within defendant's exclusive control and Frekhtman's injury resulted from negligence related to the water heater's temperature, the defendant was more likely than not to be at fault. And that is the standard, right? Because you can't expect somebody to exclude every possibility, right? There's so many possibilities of what might have happened. So it just has to be more likely than not. And it's the same thing in regular cases. They talk about a substantial factor, and it has to be a substantial factor in bringing about the injury. It doesn't have to be the only factor, just a substantial factor. And then here they talk about more likely than not. Sometimes they talk about the greater weight of the evidence. So whatever is a little bit, you just have to tip the scales, like 51 to 50, 51 to 49, tip the scales, and then you win. It doesn't have to be like beyond a reasonable doubt where I have to prove that there's no doubt that the defendant was negligent, right? Because you could always come up with a doubt. You could always, just using your imagination, you could always come up with something. So in civil cases, you don't have that. In criminal cases, you do have beyond a reasonable doubt, because you don't want someone to lose their liberty and go to prison, right, or be convicted of a crime unless there's no reasonable doubt that they did it. But in civil cases, it's just more likely than not, so the greater weight. And so what they're saying here is that, more likely than not to be at fault. A plaintiff, this is the court's writing here, a plaintiff is not obligated to eliminate every alternative explanation for the event, and instead must only show that the likelihood of other possible causes of the injury is so reduced that the greater probability lies at the defendant's door. So the greater probability, right, that's what we talked about. And although a witness testified that the lock on the door had been changed, that there was a possibility that the room was left unlocked, the court was also free to reject the theory of the phantom vandal. Yeah, I mean, like someone went in there and vandalized switch up the temperature on a hot water heater. That's pretty much, very, very unlikely. But here's what they did with damages. Now, so with liability, I agree with this decision. It was well thought out. Res ipsa loquitur is a valid theory, and I believe it does apply here. Those three prongs, it fits them, so everything is good. But with damages, the $632,000 was reduced to only $100,000. And based on what? I mean, they say, we agree with defendant, however, that the award of damages for future pain and suffering deviates materially from what would be reasonable compensation. Based on the evidence presented at trial, we conclude that $100,000 for future pain and suffering damages is the maximum amount the court could have awarded as reasonable compensation. And so they cite to these cases. And the cases they cite to, and I think the blog also mentions, I read some of the cases they cite to, and I was like, why are they citing to these cases? The cases they cite to deal with like paralysis and other very, very catastrophic injuries that have nothing to do with burn injuries. So it's unclear why they cite to those cases and what does it have to do with the value of burn injuries. But it appears from this decision that what they're doing is they are keeping the past amount of $450,000, but they're saying that the 182 for the future is too high. So they're telling the plaintiff to take 100 instead of 182. And if you don't want to take 100, then within 20 days, file a petition and then they'll give you a new trial. So that's the decision. And there's no real rationale, right? Like the same way that they talked about the judge's decision shouldn't be, changed on the liability aspect. Here they are changing the judge's decision and they're not really giving too much rationale except for saying that it's excessive. So I hope this has been helpful. I think this is interesting because they talk about every aspect of a personal injury case. And this was an interesting case because you don't see res ipsa that often. So, and then it also talked about the damages awards. Okay, let us know what questions you have. Thank you so much and have a great day. Bye-bye.